Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Supreme Court bench of Justices Hima Kohli and Ehsanuddin Amanullah, which today continued hearing the contempt case against Patanjali Ayurved Limited, Acharya Balkrishna and Baba Ramdev over misleading advertisements. As you know, the petition has been filed by Indian Medical Association against Patanjali's advertisements attacking allopathy and making claims about curing certain diseases. On 2nd April, the court had refused to accept the first apology filed by Patanjali MD after noting that it was not unqualified. Last week, the court refused to accept the second affidavit of apology filed by the Patanjali MD. The court also noted that Acharya Balkrishna, the managing director of Patanjali, and Baba Ramdev, the co-founder of Patanjali Ayurved Limited, had sworn an affidavit with non-existing flight tickets to evade personal appearance before the court. If you remember, the court had also come down heavily on the Uttarakhand state authorities for failing to take action against Patanjali under Drugs and Magic Remedies Act. In today's hearing, the bench personally interacted with them and asked as to why they acted in violation of the undertaking given to the court. Both Ramdev and Balkrishna personally appeared before the court and expressed unconditional apology for publishing misleading advertisements and making comments against allopathic medicines in breach of the undertaking given before the court. Patanjali's counsel, Senior Advocate Mukul Rohtagi, told the court that they were ready to give a public apology to show contrition. The bench adjourned the hearing till 23rd April to give them an opportunity to redeem their acts. Stay tuned. The Supreme Court bench comprising Justices Sanjeev Khanna and Dipankar Datta today heard the petitions seeking complete verification of electronic voting machine against voter verifiable paper audit trail, that is VVPAT records. Currently, the Election Commission of India randomly verifies 5 EVMs per assembly segment as per the existing practice. Representing the petitioner, that is Association for Democratic Reform, Advocate Prashant Bhushan proposed 3 suggestions for relief. First, returning to the paper ballot system. Second, allowing voters to physically deposit VVPAT slips in the ballot box and counting them. And third, making the glass transparent and counting all VVPAT slips. Bhushan argued that the current system lacks transparency and is susceptible to malpractices. He strongly advocated for parallel counting of VVPAT slips. Senior advocates Santosh Paul, Huzaifa Ahmadi, Anand Grover and Sanjay Hegde also made submissions advocating for the counting of at least 50% of the VVPATs. Representing the Election Commission of India, Senior Advocate Maninder Singh argued against the doubts cast on EVM and VVPAT functioning, calling them vague and baseless. He detailed the security measures in place for EVMs, including sealing them in the presence of candidate representatives and keeping them tamper-proof. He stated that manually counting all VVPAT paper slips would be labor-intensive, time-consuming and prone to human error and mischief. Further, the bench expressed doubts about the feasibility of counting all slips due to potential human errors, as well as concerns about the practicality of physically counting votes given India's large population. The matter will now be heard on 18th April. Notably, the first phase of the Lok Sabha elections commences the very next day, that is 19th April. Do tell us about your views on this in the comment box. The Supreme Court today directed the states which have not yet responded to the PIL filed by National Federation of Indian Women regarding increase in mob lynching incidents. The direction is to file detailed affidavits specifying the steps taken by them in respect of the mob lynching incidents mentioned in the PIL. The petitioner has added all states as respondents, out of which only states of Madhya Pradesh and Haryana have filed their responses. If you remember, in the Tehseen Poonawala's judgment, the top court had issued comprehensive guidelines to the union and state governments regarding the prevention of lynching and mob violence. Today, Advocate Nizam Pasha, appearing for the Federation, tried to show that the guidelines were not being followed. He read some part of the affidavit submitted by the state of Madhya Pradesh to show how an act of mob lynching was being given the color of a normal fight. After noting that most of the states had not filed affidavits specifying the steps taken on the mob lynching incidents mentioned in the petition, the bench of Justices B.R. Gawai, Arvind Kumar and Sandeep Mehta granted 6 weeks to the states to give a detailed response. Soon after this, Justice Arvind Kumar inquired from Pasha whether the incident of the murder of tailor Kanhaiya Kumar in Udaipur was mentioned in the petition or not. Not sure about the fact, Pasha assured the court that the incident would be mentioned in the petition if not already mentioned. The matter will now be heard post-Supreme Court's summer vacation. Stay tuned. The Delhi High Court has dismissed a plea challenging the union government's decision to dissolve the Maulana Azad Education Foundation, which was set up in the year 1989 for promoting education among educationally backward minorities. In February, the union government had taken the stand that the foundation had become obsolete as there was a dedicated ministry holistically executing schemes for the benefit of the minorities. The present plea challenged the union government's order by which the foundation was instructed to carry out the closure process. It further submitted that such an abrupt, opaque and completely arbitrary decision to dismantle an almost 4-decade-old institution and scavenge its assets was bound to have an adverse impact on the lives of a number of students, schools and NGOs. But finding no merit in the petition, the bench of Acting Chief Justice Manmohan and Justice Mini Pushkarna dismissed it. The court observed that the decision to dissolve the foundation was a well-considered one. Coming to the update on the petitions filed by comedian Kunal Kamra and others challenging Rule 3 of the Information Technology Rules of 2021 before the Bombay High Court. The 2023 amendment to the IT Rules of 2021 empowers the government to establish an FCU, that is a fact-check unit, to identify fake, false and misleading information about its business on social media. The matter was heard by Justice A.S. Chandurkar. He was assigned the matter after the division bench of Justices Gautam Patel and Neela Gokhale delivered a split verdict in the writ petitions challenging the amendment. While Justice Patel had held the rule to be struck down in its entirety, Justice Gokhale held the rule was intra-vires. Senior advocate Navroz Sirvai, appearing for Kamra, told the court that the purpose of a government fact-check unit was not to protect the public from misinformation, but to bring total state censorship over anything that the government does not want people to know, discuss, debate or question. He emphasized that no entity, especially the government, should have the authority to define what is true or false. Sirvai argued that if the amended rule were in line with Article 19 of the Constitution, it would serve no purpose as it would merely restate the rights already guaranteed by the Constitution. However, its existence suggests that it goes beyond constitutional boundaries and restricts certain rights, thus implying a violation of the constitutional rights. Observing that the University Grants Commission regulations are binding on the universities, the Supreme Court has directed reinstatement of teachers at Jamia Millia Islamia on a permanent basis. These are teachers who were denied regularization by the university even after UGC's letter to the university directing regularization of those teachers who were selected through a regular selection process and possessed required qualifications. The university had not regularized them and instead rolled out a fresh selection procedure. The Supreme Court opined that appellants or the teachers having been appointed after undergoing a regular selection process and possessing relevant qualifications as per the norms of UGC should have been continued on the posts merged with the regular establishment of the university instead of adopting the fresh selection procedure. Accordingly, the appeal was allowed and the appellants were directed to be reinstalled within 3 months. In another update, the Supreme Court has issued notice in a public interest litigation raising the issue of exclusion of persons with disabilities from appointment to the district judiciary in many states. The petitioner contends that the judicial service rules of many states do not provide for the PWD, that is, Persons with Disability quota, under the Rights of Persons with Disabilities Act of 2016. That discrepancies in the appointment of judicial officers result in denial of adequate representation for persons with disabilities in the judicial services. The existing judicial services rules of different states are not only ultra-vires the Act but also violative of Articles 14, 19 and 21 of the Constitution. The bench led by CJI Chandrachud and comprising Justices J.B. Pardiwala and Manoj Mishra agreed to consider the issue. And lastly, the Supreme Court has refused to interfere in the petition filed by two practicing advocates from Gujarat challenging an inquiry ordered by the Gujarat High Court against them for alleged misconduct of forging their client's wakalatnama. The two advocates were accused of forging the wakalatnama of their client during a case involving the release of his seized car. The High Court ordered for the complaint and investigation after the client himself appeared in the court and denied engaging the lawyers or filing the petition. The two lawyers had approached the Supreme Court alleging that the High Court had overlooked their explanation and sought a stay on the order of inquiry, citing reputational and professional concerns. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.